Hello everyone. In this lecture we will try to understand what are the fundamental distinctions between these two expressions, decree and order. Decree and order. So you see, decree, which is getting covered by section 2 subsection 2 of CPC, it has been defined there. But when we talk about order, order has been defined in section 2 subsection 14 of the Code of Civil Procedure 1908. Decree, it is passed in a suit initiated by presentation of a plaint, P-L-A-I-N-T, plaint, and section 26 order number 4, where is very important here, section 26 order 4, where we will learn how the suit is instituted. You see, the suit is instituted by the presentation of plaint or in any other manner as prescribed by the law, by the Code of Civil Procedure. Now this plaint must be supported by affidavit. And plaint means what? Plaint means such a document where those particulars are mentioned which we will get in order number 7 of the Code of Civil Procedure 1908, order number 7. Now who writes those particulars in the plaint? The plaintiff. The plaintiff writes the plaint. What the plaintiff writes? The cause of action. The cause of action, why the plaintiff came to the court, all these things the plaintiff writes on the plaint. So when the plaintiff presents this in the court, the plaint, then the suit is instituted. So in this way, in the suit, the decree is passed. But if we talk about order, the order can be passed in any type of suit. Like, let's say, if the suit has been instituted by the plaint of the plaintiff, or let's say through application or by petition, if the suit has been instituted like this, in all these suits the order can be passed. Okay, the order can be passed. So we have to keep this in mind. A decree can only be passed in a suit which has been commenced by presentation of a plaint. An order may originate from on the other hand, an order may originate from a suit by presentation of a plaint, or may arise from a proceeding commenced by a petition or by an application. Okay, decree, we should keep this in our mind, that decree deals with the substantive legal rights of the parties involved in the suit, which means decree deals with the substantive legal rights of the parties in the suit, which indicates if there is any right of the parties, the court here conclusively determines the legal rights of the parties. And we have already covered this portion in my lecture. You can go through the video again. Decree. And if you talk about order, the order deals with procedural legal rights of the parties. So see, a decree is what? A decree is an adjudication, conclusively determining the rights of the parties involved in the suit with regard to all or any of the matters in controversy. We have already covered the topic decree in our last lecture. And you see, an order, on the other hand, may or may not finally determine such rights. An order may or may not finally determine such rights. Then, decree, normally it is appealable. Normally a decree is appealable unless it is barred by law, unless it is prevented by law. Decree can be appealed. Parties can appeal for the decree, but if it is barred by the law, then it cannot be appealed. And if you talk about order, only those orders can be appealed which have been provided in section 104. Section 104 and order 43 of the Code of Civil Procedure 1908. So if you talk about order, only those orders can be appealed which have been provided in section 104 and order 43 of CPC. Okay. So every decree is appealable. Every decree is appealable. We have to keep this in our mind. Unless otherwise expressly provided. Section 96 subsection 3. Here it is important. Every decree is appealable unless otherwise expressed, provided. Section 96 subsection 3. But every order is not appealable. Every order is not appealable. Only those orders are appealable which are specified in the code. That is section 104 and order 43 rule 1. Section 104 order 43 rule 1. These orders, rules, sections are very important. Okay. So another distinction between decree and an order is that a second appeal can also be made against the decree passed in the appeal. A second appeal can also be made against the decree passed in the appeal. For example, let's say if in a particular court a decree has been passed, in a particular court, a civil court, a decree has been passed. Now let's say against this first decree an appeal has been made, and when the appellate court made the second decree after listening the appeal against the first decree, it will be regarded valid as per CPC. Similarly, in this way, an appeal can also be made against this second decree and so on. So the decree which is passed through appeal, another appeal can also be made against such decree in the court. So a second appeal can also be made against the decree passed in the appeal. So if you talk about order, there is no provision for second appeal against the order passed in appeal. Okay, because no such provision has been provided in CPC. The order which came in the appeal, for that no second appeal can be done. Okay, and decree can be preliminary. Decree can be preliminary in nature, or it can be final, or partly preliminary, or partly final, like this. So it is mentioned in section 2 subsection 2, as we have discussed. The decree has been explained. It has been explained there. But you see, the order is always final. There is only one decree. Another thing, there is only one decree in a suit. Okay, but there may be many orders in a suit. See, here what is happening? Except in certain suits, in certain cases, where two decrees, one this preliminary and the other final, are passed, in every suit there can be only one decree, except in certain suits, except in certain cases where two decrees, one preliminary and the other final, are passed. In every suit there can only be one decree. But you see, in the case of a suit of in the case of a suit on proceeding, a number of orders may be passed. Okay, and we have already discussed that a decree is an adjudication, uh, conclusively determining the rights of the parties with regard to all or any of the matters in controversy. An order, on the other hand, may or may not finally determine such rights of the parties. Now, there is one case law in Board and Board versus Himalaya paper, AIR 19. In this case, the Rajasthan High Court held that a judgment stands on a different footing from an order and a decree. The word, this formal expression, this term, word formal expression, are not used in the definition of judgment, which is used in the definition of decree and order. And the Rajasthan High Court, the Honorable Court, High Court, expressed there that no statement need be given by the judge in a decree. So, regarding the judgment, this topic we will cover in the next lecture. We will cover this topic, judgment. Thank you.